Triumph IAS Daily Prelims Practice MCQ is a program that is exclusively designed for CSE 2023 aspirants. In this video discussion, we will discuss UPSC CSE Prelims previous 25-year questions.
Question number 1. Consider the following statements. Number 1. The Rajya Sabha has no power either to reject or to amend a money bill. Number 2. The Rajya Sabha cannot vote on the demands for grants. Number 3. The Rajya Sabha cannot discuss the annual financial statement. Which of the statements given above are correct? Option A, 1 only. Option B, 1 and 2 only. Option C, 2 and 3 only. Option D, 1, 2 and 3. The correct answer is option B. Number 1. A money bill can be introduced only in Lok Sabha. After it is passed by that house, it is transmitted to Rajya Sabha for its concurrence or recommendation. The power of Rajya Sabha in respect of such a bill is limited. Number 2. Rajya Sabha has to return such a bill to Lok Sabha within a period of 14 days from its receipt. If it is not returned to Lok Sabha within that time, the bill is deemed to have been passed by both houses at the expiration of the said period in the form in which it was passed by Lok Sabha. Again, Rajya Sabha cannot amend a money bill, it can only recommend amendments, and Lok Sabha may either accept or reject all or any of the recommendations made by Rajya Sabha. Number 3. Rajya Sabha does not vote on demands for grants of various ministries, a matter exclusive reserved for Lok Sabha. No money, however, can be withdrawn from the Consolidated Fund o India unless the appropriation bill has been passed by both the houses. Number 4. Similarly, the finance bill is also brought before Rajya Sabha. Besides, the department-related parliamentary standing committees that examine the annual demands for grants of the ministries' departments are joint committees having 10 members from Rajya Sabha. Question number 2. Which of the following statements are correct? Number 1. A bill pending in the Lok Sabha lapses on its prorogation. Number 2. A bill pending in the Rajya Sabha, which has not been passed by the Lok Sabha, shall not lapse on dissolution of the Lok Sabha. Select the correct answer using the code given below. Option A, 1 only. Option B, 2 only. Option C, both 1 and 2. Option D, neither 1 nor 2. The correct answer is option B. Articles 107 and 108 of the Indian Constitution deals with these provisions. The position with respect to lapsing of bills is as follows. Cases when a bill lapses. Number 1. A bill originated in the Lok Sabha but pending in the Lok Sabha lapses. Number 2. A bill originated and passed by the Rajya Sabha but pending in Lok Sabha lapses. Number 3. A bill originated and passed by the Lok Sabha but pending in the Rajya Sabha lapses. Number 4. A bill originated in the Rajya Sabha and returned to that house by the Lok Sabha with amendments and still pending in the Rajya Sabha on the date of the dissolution of Lok Sabha lapses. Cases when a bill does not lapse. Number 1. A bill pending in the Rajya Sabha but not passed by the Lok Sabha does not lapse. Number 2. If the President has notified the holding of a joint sitting before the dissolution of Lok Sabha, does not lapse. Number 3. A bill passed by both houses but pending assent of the President does not lapse. Number 4. Some pending bills and all pending assurances that are to be examined by the Committee on Government Assurances do not lapse on the dissolution of the Lok Sabha. Question number 3. Consider the following statements. Number 1. The Parliament of India can place a particular law in the 9th schedule of the Constitutions of India. Number 2. The validity of a law placed in the 9th schedule cannot be examined by any court and no judgment can be made on it. Which of the statements given above are correct? Option A, 1 only. Option B, 2 only. Option C, both 1 and 2. Option D, neither 1 nor 2. The correct answer is option A. Number 1. Once a law is enacted and included in the 9th schedule, it gets protection under Article 31-B, validation of certain acts and regulations, and is not subject to judicial scrutiny. Number 2. The validity of a law placed in the 9th schedule cannot be examined by any court and no judgment can be made on it. Hush 1. A bill originated in the Lok Sabha but pending in the Lok Sabha lapses. Number 3. The mandate of 9th schedule is to prevent judicial scrutiny, but in a landmark ruling in Aya Coelho vs. State of Tamil Nadu, 2007, the Supreme Court of India ruled that all laws, including those in the 9th schedule, would be open to judicial review if they violated the basic structure of the Constitution. The Supreme Court judgment laid that the laws placed under 9th schedule after 24 April 1973 shall be open to challenge in court if they violated fundamental rights guaranteed under Article 14, 19, 20 and 21 of the Constitution. Number 4. The court also said that by using the power to amend the Constitution, Parliament cannot alter its basic or essential features like federal structure, separation of power between the three organs of the states, and judicial review, among other things. Question number 4. Which one of the following reflects the nicest, appropriate relationship between law and liberty? Option A. If there are more laws, there is less liberty. Option B. If there are no laws, there is no liberty. Option C. If there is liberty, laws have to be made by the people. Option D. If laws are changed too often, liberty is in danger. The correct answer is option B. Option B is an appropriate choice because it was a statement made by John Locke. He, in Second Treatise of Civil Government, wrote, "Where there is no law, there is no freedom." In 1689, he also wrote that the end of law is not to abolish or restrain, but to preserve and enlarge freedom. No law would give license, unregulated liberty. Therefore, B is correct. But, then such statements are not to be considered objective realities. If there are no laws, there can be either complete liberty, because nothing restricts the actions of citizens, or no liberty because then lawlessness can heavily curtail liberty. It really depends. It is an extreme statement to say that when there are no laws, there is no liberty. Can we say there is no liberty in a jungle? There can be liberty despite the absence of laws. Question number 5. With reference to the Constitution of India, prohibition or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which one of the following? Option A. The decisions taken by the Election Commission of India while discharging its duties cannot be challenged in any court of law. Option B. The Supreme Court of India is not constrained in the exercise of its powers by laws made by the Parliament. Option C. In the event of grave financial crisis in the country, the President of India can declare financial emergency without the counsel from the Cabinet. Option D. State legislatures cannot make laws on certain matters without the concurrence of the Union legislature. The correct answer The correct answer is option B. One of the important instances of application by the Supreme Court of Article 142 was in the Union Carbide case relating to the victims of the Bhopal gas tragedy, where the court felt a need to deviate from existing law to bring relief to the thousands of persons affected by the gas leak. In this judgment, the Supreme Court, while awarding compensation of $4.70 million to the victims, went to the extent of saying that to do complete justice, it could even override the laws made by Parliament. By holding that prohibitions or limitations or provisions contained in ordinary laws cannot, ipso facto, act as prohibitions or limitations on the constitutional powers under Article 142. By this statement, the Supreme Court of India placed itself above the laws made by Parliament or the legislatures of the states.